Hi, everyone. Welcome to the last panel of our day here at the convention. This is the panel called Are MDL Judges Too Powerful? My name is Britt Grant. I sit on the 11th Circuit Court of Appeals, and I'm pleased to be here virtually moderating today, and I know we'll have a great discussion with these esteemed panelists. Necessity is said to be the mother of invention, and I think that probably applies to the development of the MDL system that we have today. In the late 60s, judges and litigants alike were staring down the barrel of a vast array of complex litigation cases that have arisen around the country. These days, nearly half of all civil cases, it seems, are appearing in MDLs. They end up being consolidated. And a vigorous debate has emerged about both the costs and also the benefits of this particular litigation structure. So we've got the pleasure today of hearing from two of the top scholars in this area, as well as one of the leading practitioners. And I'll introduce each of the panelists much more briefly than their vast resumes and accolades should really allow for. But then I'll let them kick off the conversation with their own set of remarks. And after that, I'll pose a few questions and let them engage with one another. And then we'll open up to the audience to ask the questions that you have of these great panelists. So please be sure to jot down your thoughts as you're watching our panelists today offer their insights. Let's begin. I'll introduce the panelists first. Professor Elizabeth Birch is the Fuller E. Callaway Chair of Law at the University of Georgia. Go Dogs. Her areas of research include complex litigation, mass torts, multi-district litigation, civil procedure. Professor Birch earned her bachelor's degree cum laude from Vanderbilt University and her JD from Florida State University. She's an award-winning scholar, and she's won, among other honors, the American Law Institute's Early Career Scholars Medal in 2015, as well as awards for teaching and student support at every university where she's been a law professor. Next, we'll hear from Professor Brian Fitzpatrick. He's the Milton R. Underwood Chair in Free Enterprise at Vanderbilt Law School. His research at Vanderbilt focuses on class action litigation, federal courts, judicial selection, and constitutional law, as well as, of course, MDLs. He graduated first in his class from Harvard Law School, went on to clerk for Judges Scanlon on the Ninth Circuit, and then for Justice Scalia on the US Supreme Court. Professor Fitzpatrick received his undergraduate degree summa cum laude from University of Notre Dame, a popular university amongst our Federal Society friends in the last recent weeks. Among many other honors and awards, Professor Fitzpatrick has received the Hall Hartman Outstanding Professor Award for Excellence in Classroom Teaching. Last but not least is Mr. Christopher Seeger. He is a founding partner of the Seeger Weiss firm, as well as one of the nation's leading attorneys in complex and mass tort actions. He's earned leadership appointments from state and federal courts throughout the United States. There are too many to mention them all specifically, but highlights include his 2012 appointment to lead the multi-district litigation against the NFL arising out of concussion-related injuries sustained by former NFL players. His 2016 appointment to the plaintiff steering committee for the MDL concerning the Volkswagen diesel emissions scandal, and his role as co-lead counsel in the ongoing 3M Combat Arms Earplugs Products liability litigation, where he represents thousands of US military members who are suing over hearing loss and tinnitus. Mr. Seeger received his undergraduate degree summa cum laude from Hunter College of the City University of New York, and his law degree magna cum laude from the Benjamin N. Cardozo School of Law. With that, let's get started with the panel. Professor Birch, would you like to kick things off?
Sure. Thank you, Judge Grant. I appreciate the warm introduction.
Take yourself off mute, please.
Can everybody hear me okay? Okay, great. I appreciate the warm introduction from Judge Grant. For those of us who are not embroiled in MDL every day, I thought that I would take just a minute and sort of talk a little bit about what MDL is. I expect that you have probably heard of it, even if you don't realize that you've heard of it. MDL includes massive cases like the opioid lawsuits, the tout cases, the Roundup litigation. And essentially what MDL is it's our system for efficiently handling federal claims that have a related factual question. So MDL includes antitrust, it includes securities, it includes employment and IP suits. But as Judge Grant mentioned, the cases that you hear most about tend to be the products liability cases. So just to give you a sense as to some of the kind of facts and figures here, products liability and sales practice proceedings make up 1/3 of all of the MDL proceedings. But if you look at the number of actions within the proceedings, products liability cases make up 89 to 95% of all MDL actions. So of the products liability cases, at least in my data set, only about 27% of those actually settled as class actions. Those tend to be the economic claims, at least setting aside the BP oil spill and the NFL concussion case. Whereas the bigger personal injury cases that you hear a lot about tend to be settled through private aggregate settlements. So in my data set, it was about 45%. And that's going to be my focus today, is this private aggregate settlement. So for these massive personal injury cases, the moment of centralization alters the leverage in a case. Unlike the more demanding prerequisites for class certification, where you have to have common questions predominate over individual ones, for MDL, you just need a single common question of fact. So that means that MDL can host a variety of loosely related interests. The parties' aims and desires might coalesce on some issues, and they might diverge significantly on other issues. Plus, unlike class actions, there's no ability to opt out. Both plaintiffs and the defendants can effectively be dragged across the United States to a jurisdiction that would ordinarily lack personal jurisdiction over them. And then when judges appoint lead lawyers to spearhead those cases, typically the insiders that we see time and again, the plaintiffs may find themselves being represented by lawyers that they didn't hire, by lawyers that they've never met, who were chosen for their expertise in practical administration and settlement, not according to the adequate representation requirements of Rule 23 and class actions. So as this suggests, there's a big dichotomy between class actions on the one hand and non-class MDLs on the other, and we tend to call the non-class MDLs just MDLs. So when judges certify a class under Rule 23, of course, they have a great deal of power. Rule 23 gives them a lot of power, but it also builds in checks and balances, both for class counsel and for the judge herself. So to address these longstanding principal agent concerns between class members and class counsel, Rule 23 asks the judge to appoint class counsel and award class counsel's fees, consider adequate representation, and make sure that any settlement that results is fair, reasonable, and adequate. And then we have checks on the judges. So to check the judicial process, Rule 23F paves the way for appellate review of the class certification decision. Objectors can come in and object to the settlement's fairness or to the attorney's fees. And if the judges and the parties ignore those objections, then the objectors can appeal them. But these formal checks and balances largely fall by the wayside when there's no class action that's actually certified. So with class actions off the table, closure becomes even more difficult for corporate defendants. So they end up striking deals with the lead plaintiff's attorneys, often that require those lawyers to recommend that all of their clients enter into the settlement, and then some of which require that those attorneys take steps to withdraw from representing clients who refuse to settle. So despite the thorny ethical issues that those deals raise, private settlements and the focus on pretrial proceedings means that there are very few issues within an MDL that are ultimately appealable. And yet, we see parties implementing a number of procedural innovations that exist nowhere in the federal rules of civil procedure, each of which raise fundamental questions that can often go unchallenged. So for example, to varying degrees in these private settlements that I've been talking about, 53% of the judges actually approved a private settlement, which of course blurs conventional wisdom, suggesting that private settlements are just that. But it also raises questions about judges' source of authority to do so. Of course, judges are in a really tough position here. Unless they've ruled on the merits through the adversarial process, they may know only what the lead plaintiff's lawyers and the defendants want them to know. And so looking more closely at those proceedings that I've been talking about, I found that nearly a third of the judges who approved those private settlements hadn't ruled on any merits-related motions or presided over a bellwether trial before they ended up approving those private deals. Then, of course, there are other types of orders that if you're not an insider in the area, you probably never heard about before, like Lone Pine orders, which seem to short circuit the summary judgment process, direct filing orders, which raise questions about personal jurisdiction, and then mandatory participation agreements for a lead plaintiff's counsel that require those lawyers who aren't in leadership positions to sign on and sign over a portion of their fees in order to get access to discovery. So there are questions, of course, about whether those are contracts of adhesion. So I realize that I sound critical and perhaps probably more critical than I mean to be. But the negotiation parties are often approaching the court in unison, which means that MDL judges don't have the benefit of adversarial airing of a lot of these different issues. But my worry is that the drive to settlement, they may be overshadowing core procedural values. Values like the reviewability of judicial decisions and orders, whether there's adequate representation in appointing non-class MDL leaders, whether there's transparency, particularly in litigation that bears on public health and safety. And then I also worry about the development of state substantive law. So there are tons of questions, for example, the public nuisance doctrine when it comes to the opioid lawsuits that really haven't been fully fleshed out, and yet we tend to rely on those doctrines quite a bit. So as the Sixth Circuit recently reminded us in one of the successful mandamus actions in the opioid litigation, MDL is not some sort of border country, judicial border country, where the rules are few and the law rarely makes an appearance. So MDL judges don't have nationwide jurisdiction over these cases. Instead, what makes the MDL court's exercise of power constitutional is this idea that the original court does have jurisdiction, and the complete fiction that these cases are going to somehow be remanded back to the original court at some point. So data shows that fewer than 3% of those cases that are transferred to an MDL ever return home. So what can be done? I'll conclude with just a couple of comments here. I have a lot to say on this topic, but I'll limit myself. I think that we can recognize the really important gaps that MDLs fill, but we can nevertheless reintroduce some guardrails that can help effectuate individual rights and state rights on which procedure is based. So first of all, I think judges should really focus on adequate representation when they're appointing lead lawyers in the same way that judges are focused on adequate representation in class actions. Currently, there's an MDL subcommittee that's considering something akin to this. And then second, I think that courts shouldn't be afraid to remand cases. So they can remand cases at key points in any sort of proceeding, perhaps at the beginning for cases that fall outside of the types of issues that the lead lawyers decide to work up. Maybe again at the end when there's a global settlement and you have cases that don't want to settle. But the point is that remands can give plaintiffs control and voice opportunities. They can give defendants an opportunity to engage in case-specific motion practice, which of course can help develop state substantive law. Remands can help correct judicial error by building redundancy into the process. As we've seen, there are very few appellate opportunities in an MDL, but when the state substantive law varies and it lies at the heart of the dispute, you don't have to hold up the whole proceeding through an interlocutory appeal, particularly if those issues can be worked out on a remand. Remanding cases can relieve the substantive burden that's caused by aggregating state law claims with minimal commonality. So in this sense, we can ease some tension between the MDL on the one hand and federalism issues on the other. And finally, remands can allow for diverse communities to participate in fact-finding and democracy. So I will turn it over to Brian at this point. I know he has more to say on this issue, and I look forward to hearing about it.
Thank you, Professor Birch, for that great introduction to multi-district litigation. And I'm going to really pick up where you left off, which is your concern about all these other procedural values that might be getting short shrift in our current MDL process. And I think a fair summary of both your criticism of the MDL and a criticism from a lot of commentators and scholars is this. Our MDL process has focused on one procedural value, efficient case processing, to the exclusion of all of the other procedural values that we care about in our civil justice system. And let me just say, I don't think this is particularly surprising that this is how the MDL has turned out, to focus on that one value of efficiency above all others, because the political constituency for the MDL statute in 1968 was federal judges. They were concerned that their dockets were going to be overwhelmed by mass torts. They went to Congress and asked for a solution. And it's not surprising. The solution is very good at relieving docket pressure of federal judges, but it may not be so good on all of these other procedural values that Professor Birch has listed for us today. I want to focus on one procedural value. I think it is the most important procedural value, and I think our MDL system is neglecting it. That value is accuracy. What is the point of having a court system if we're not reaching the right answers in the cases that are being litigated? There is no point in my view. Accuracy is the most important job of a court system. We want resolutions to match the actual merit of the cases, the claims, and the defenses. I think our MDL system is a recipe for very inaccurate decision making. And I say that because the way that the statute works is it takes decisions that would be handled by many different judges and gives all of the decisions to one person. One single person gets to decide everything. It could be dozens or hundreds or even thousands of cases. One person decides everything that goes on in those cases. Now, formally, the MDL system is only there for pretrial proceedings, but we know, as Professor Birch just said, that 97% of the cases end in pretrial proceedings in multi-district litigation. So that one MDL judge is controlling everything for 97% of half of the civil cases in the federal system, as Judge Grant reminded us at the outset. Even when the 3% of cases are remanded, they are tainted by the law of the case doctrine. It is hard for the judges on remand to reconsider things that have already been decided by the MDL judge. And all of this happens with almost no appellate opportunities. Professor Birch mentioned a Sixth Circuit mandamus petition that was successful in the opioid litigation. That is an aberration. There are very few opportunities to appeal the decisions of MDL judges because they're all pretrial proceedings. There's no final judgment. So all this power is in the hands of one person. This is not the way we usually think we get the best answers to questions, is by letting one person decide everything. We usually think if we have more minds thinking about something, more diverse minds thinking about something, we're going to get better answers in the end. That's an intuition I think a lot of us have. There's a field of mathematics that has formalized the intuition. It's called the many minds literature. It flows from something called the Condorcet jury theorem. But it's basically just this idea that if you add more people to a group thinking about something, you're more likely to get good answers, so long as you don't have any reason to think that the average competence of the group is going to fall as you add more people, and so long as you think that you're going to get more diverse perspectives as you add more people to the group. And so I think that the recipe of our MDL system is the opposite of the recipe that the many minds literature, the Condorcet jury theorem, mathematicians would tell us is the way to get the best answers. And I'll just give you one example. Professor Birch mentioned it earlier, this roundup litigation. It's all been consolidated before a good friend of mine, Judge Chabria. We clerked together. He clerked for Justice Breyer. He has all these roundup cases, thousands of cases, alleging that the weed killer is causing cancer. And he decided not to grant summary judgment for Monsanto. This is a question that's been looked at for decades. Does the active ingredient in Roundup cause cancer? It's been looked at for decades by scientists, by governments, by lots of different people. And Monsanto moved for summary judgment and said that what the plaintiffs were relying on was not very good science. Their experts should be excluded. And Judge Chabria said, you know what? I think this evidence is pretty weak. Evidence that the Roundup causes cancer is pretty weak. And if I were in most other circuits, I would actually exclude the expert and grant summary judgment. But because I'm in the Ninth Circuit and our law on experts is so permissive, I have to let these cases go forward. And because of that, you know, Monsanto is now already settled up to the tune of $10 billion. If this litigation had been somewhere else, it could have been zero. This is not the way to get accurate outcomes, is by putting all of our eggs in one basket and hope that that person does not drop the basket. Now, if we wanted to add more minds to our MDL system, what could we do? You know, one proposal is the one that Professor Birch made: remand more cases earlier. I want to focus on two other ideas. One is more appellate review. We could get 3-judge panels on appeal more involved in what the MDL judge does. I think that would improve accuracy. We'd quadruple the number of minds we have on these problems. But it does lose a lot in efficiency, because everything has to stop for a year or two every time you want to take an appeal. Not many things would end up being able to be appealed, so we wouldn't get many minds very often. Something I like better than appellate review is sharing each MDL among multiple judges. Instead of just choosing one judge, we could either have a panel of 3 judges that presides over the MDL. We could also try something different than the 3-judge panel district court that we use sometimes for election cases. We could try dividing MDLs into pieces and then giving each piece to a different judge. I actually really like this dividing approach, even though you're going to lose uniformity because some judges might be deciding different pieces differently. You gain a lot in accuracy because you have different people independently assessing the merits of these various questions over time. It's our common law system working. You also have some collateral benefits by breaking things up into pieces. So, you know, one of the things that Professor Birch has been concerned about in her work is we get these repeat players appointed every time by the MDL judges to run the cases as lead counsel. Well, if you broke MDLs up into pieces, then you could have different judges choosing different leadership teams. You could get more lawyers involved in MDL leadership. One of the big concerns that a lot of people have is the lack of diversity of the leadership teams that are appointed in MDLs. If you had more judges with more pieces, you have more opportunities for lawyers to participate. So we get accuracy gains, we get diversity gains. If we made one piece per circuit, we wouldn't have that problem that Judge Chabria had, where he had to apply Ninth Circuit law to all the cases. If we had one judge presiding over all the cases filed in one circuit, we could have each circuit's law applying to the cases that were originally filed there. So we could match up the federal law with the cases where federal law should be applied there. So I think there's a lot of benefits to getting more minds involved in the MDL. Accuracy as well as some of these collateral benefits. I think there's a way to do it without losing too much in efficiency. I'm very much looking forward to hearing what our next panelist, Christopher Seeger, has to say about that.
Thank you, Brian, and thank you, Beth, for your comments too. So, you know, I'm living in the world here that's being somewhat criticized, and I have a very different perspective. It probably wouldn't surprise people, but I'd like to just back up just briefly to talk about, you know, perhaps some of the causes for the growth of the MDL and what's brought that about. I think we could look at probably 3 factors. One is Supreme Court rulings in Amchem and Ortiz, which made it for a long time nearly impossible to certify class actions involving personal injuries. And that's one component of it, because I think, as Beth mentioned, and I agree with her, that there has been a massive explosion in product liability MDLs, and those are cases that come from the fact, I believe, that you can't, you know, for a long time you couldn't certify those. Now, I can circle back later to the NFL concussion litigation, where we did get a class certified It was upheld through the Third Circuit, and we survived the cert process in the Supreme Court. So I think Rule 23 is back in play for personal injuries, but under very limited circumstances. The second thing is that we, and we shouldn't overlook this, we live in a consumer society where products are sold to millions of people. And when there is something that goes wrong, it injures huge numbers of people. If that product happens to be a drug, and it's sold to 20, 30 million people, and it has a side effect that even only affects 5 or 10% or less, you have potentially many thousands of cases. If it's a product in the Chinese drywall situation, where when drywall was imported after Katrina to rebuild homes in the Gulf Coast, it affected thousands of homes. So the potential for mass harm is great. And when it goes wrong, it's going to go wrong in a big way. And these MDLs, we have to really think about what they are. And look, this is my perspective, but these turn into big workouts. No matter who, both sides, for the purpose of a conference, need to be honest about what we're dealing with. Defendants don't want to try tens of thousands of cases. I'm not going to say plaintiffs want to try tens of thousands of cases. So generally, what the MDL has become is a data gathering tool to inform the parties, to get them to the point where they can either resolve the case or move forward. And I understand the criticism about there haven't been that many remands, but that's been a function of both sides not wanting cases. I've been in the room many times where judges have called lawyers in and said, I'll use the example of the Vioxx litigation I was a co-lead in. We tried 18 plaintiffs' cases throughout the country. At some point, Judge Fallon just called the parties in and said, look, I think you've gone as far as you can go using the MDL. So so the option is I'm going to start remanding cases by the thousands. And in that one instance, it was the defendant that said, well, we're okay with remanding, but can you hold off a little bit? We want to think about that. And I'm not trying to present a picture where the plaintiffs love the idea of trying cases throughout the country. That's a lot of work, and it's going to drive up transaction costs. So I think what ultimately happens is the parties get what they need from these MDLs. Both sides, I think, complain about the aspects of them, and I'll talk about that in a second. But I think ultimately they work very well, and they're doing exactly what they're designed to do. I think judges have done by the way, I left out point 3 because it's a point that I need to be fair about. Attorneys advertising for cases is a very simple thing. Obviously, the Supreme Court ruled that it's First Amendment speech. Anybody in today's technological world can slap up a website and get thousands of cases. I have my views on that as a plaintiff's lawyer, and I'm on both sides of that. That's got issues, and it's a good thing in some respects, but it's a bad thing in others. Because many of those law firms don't really want to litigate those cases. They want to park them until folks like me try them, create a settlement vehicle for them, and they put them in. But I want to talk about some of the things that I think that and quickly, because I think I only have 8 minutes, that MDLs have done very well. The system was not designed to take on 10, 20, 30, 100, 200,000 cases at one time. So when we talk about when the rules were created, I don't think that this was anticipated. And judges and lawyers have done a very good job dealing with a situation that was never anticipated. And sometimes we are bending and stretching the process. And I understand that when you're on the losing end of, or you're on the side of that where you're not happy with the outcome, when that rule gets stretched, we complain about it. But ultimately, I think it's doing really well. Perfect example is the Zyprexa litigation that was in front of Judge Jack Weinstein in the Eastern District of New York. It was a case that involved an antipsychotic medication. I had personally concerns. I was one of the leads. I had concerns about allowing the defendant to just go individually negotiate privately with law firms because people were on an antipsychotic medication. I felt like as a lead, I couldn't really adequately monitor how the settlement would be implemented. We went and discussed this with Judge Weinstein, and Judge Weinstein said, I don't think you defendants should go do inventory settlements. You guys should try to negotiate a global. I'll bring in a special master to it. I'm cutting through all the steps. I'll bring in a special master who was Ken Feinberg at that point to come in and administer it. And he asserted his authority to do that, even though it was a non-class settlement under Rule 23 and coined the phrase quasi-class action, which I believe when Judge Weinstein did this, he thought it not only allowed him to reach out and touch the lawyers as to attorney's fees, which is the way I think it's developed, where judges have used the term quasi-class action to control attorney's fees in non-class settlements, in MDL specifically. He had more in mind, I believe, and that was to actually look at the settlement and decide whether he was satisfied with it, and in some respects approve it. So, and in the opioid litigation, another example of where we are seeking to stretch Rule 23 once again is in the negotiation class that we have certified before Judge Polster. But the problem that we were looking to deal with was that when we tried to negotiate settlements on behalf of political subdivisions against distributors and manufacturers of opioids, we kept being confronted with the question of, who do you represent? There's only 2,500 political subdivisions in the MDL. There are 30,000 nationwide. We can't negotiate with you because we don't know if you can deliver peace. So it was really the brainstorm of Francis McGovern, who is the special master, and working with Bill Rubenstein, who's a professor and a colleague of Beth and Brian's, to come up with this negotiating class, which was just designed to be a voluntary tool. If you don't want it, you don't need it, to certify a class for negotiation purposes only. We didn't seek to certify litigation claims. We didn't seek to certify it as a settlement class. But we wanted to put together a voting mechanism so that if the political subdivisions throughout the country wanted a settlement, they could vote on it. And if it was approved, we would then move to submit the settlement pursuant to Rule 23E. So I just give those in my brief 8 minutes. I give those as examples of attorneys and judges struggling with a system that sometimes feels really like it's going to collapse under the weight of all this litigation, but I think ultimately doing an extremely good job in those circumstances. It's creative. I know it makes people uncomfortable because there are probably people listening to this that believes that there needs to be a rule that authorizes everything, and that if there's a rule of procedure, it needs to be read strictly the way it's written, and it gets pushed all the time. That happens with Rule 16, gives judges a lot of power in the district court. They force trials, they force settlements, and have managed for many, many years to get a lot of great things done by doing that. So I am a fan of the system. And the one criticism I will take on, and I'll say it briefly, and it's something that I think Beth has touched on in a lot of her work, is the lack of transparency sometimes what's going on in non-class MDLs. You know, what's going on with the money, who's getting paid, are people happy, are lawyers doing a good job? I think that the MDLs and the judges and lawyers working together again have done a very good job in the last several years of making that information more available. I'm involved with a project at NYU where we're seeking to collect data on MDL so we can make that available to judges and lawyers and folks looking at this stuff to show what I believe is true, which is that we've done a pretty good job of dealing with problems, working out solutions to big problems that sometimes could be company killers and don't often have to be, and distributing that money to people in a very efficient way. So Judge Grant, I'm sending it back to you. Got a lot
Thank
to work
you. Very interesting comments from all three of you. I will start out actually posing a question to Mr. Seeger, and then perhaps Professors Birch and Fitzpatrick can jump in to defend their ideas if he sees some disagreement. But you've obviously articulated a belief that the MDL system is working right now in dealing with these complicated cases. Do you have any specific reaction to, say, the proposal to do 3-judge panels similar to what we see in some types of election cases, or to remand cases more frequently, as our two friends from the scholarly world have suggested?
I do, Judge. The 3-judge panel, I don't have an allergic reaction to it. I think Brian and I've discussed this in the past, in passing, when I see Brian. But it's always, you know, my concern is always that when you go from one thing to the next, are you really making an improvement, or are you setting yourself up for more problems? I mean, so Brian, respectfully, to use the example like of the Roundup situation, where it might have been different in the 3rd Circuit or the 5th Circuit or the 11th Circuit, we are practicing lawyers are confronted with those decisions all the time. So that's really no different. And you know how many times I've said to myself, boy, I wish I had that class case in the 3rd Circuit or the 2nd Circuit as opposed to the 11th or the 5th. And I don't mean anything disrespectful to any of those other circuits. I'm just using them as examples, Judge Grant. But my point is that there are differences that emerge in the circuits, and until the Supreme Court takes those things up, we live with that. On the remand issue, you know, I find this a really fascinating point because, like I said, my experience has been I lately have heard defendants say more and more to MDL judges, stop putting pressure on us to continue trying cases. We're not going to do it. We don't want to settle. Some of them have even said we're not going to waive lexicon unless it's under certain circumstances. So my sense is somebody's going to test this very soon, this issue of remands. And we're going to get information from it, and we're going to find out if that's really the way the parties want to go. Plaintiffs' bar, I can tell you, have been expecting this for a long time. We expect at some point a defendant will just simply say, we really mean it this time, start remanding, and we'll start remanding cases and we'll find out. Now, I do know, last point really quick, in the transvaginal mesh litigation, cases were remanded to many different districts, and I believe cases were tried and they continued to settle. And I understand that process actually went very well. So maybe that is an option, Judge.
Chris, I'd like to just ask you a little follow-up question there. I agree that the 3-judge panel is not going to solve the roundup problem where Ninth Circuit law is applied to everybody. You know, whatever 3 judges got it would have to choose which circuit's law they're going to apply to everybody. But the problem from the roundup example, the problem it was supposed to exemplify is that why should one circuit's law be applied to everybody to begin with? If, let's say, 80% of the cases were filed in other circuits, but they're transferred to the Northern District because of the JPML, why does the Ninth Circuit law get to govern all of those cases? Do you have a problem with this idea of splitting up an MDL into pieces and maybe appointing one judge in each circuit to handle each piece, and those pieces would be all the cases filed in that circuit would go to that one judge in that circuit? We could obviously only do that for the biggest MDLs, but I think you're on the leadership team of the very biggest MDL in American history, that 3M earbud case. Would it really be so bad if there were 11 different MDLs going on, one in each circuit?
I don't know if it would be so bad, but what's different about, why should the case, the mere fact that there are many cases, be any different than if you drove your car across country and had an accident, you know, in California and you were from New York, and I'm oversimplifying this, I know there are a lot of issues packed into that, but you may wind up in that, you know, having that state's and that circuit's law applied to your fact circumstances. I think these are things that attorneys are just used to and comfortable. And when a case is MDL, we know that it's going to be the law of the circuit in which the MDL court sits that we have to now look to. So that's part of the analysis we do. And Brian, I'm not critical of it. I guess I'm just not sure if it would solve the problem that you're raising. And the busting up into pieces part concerns me a little bit, because then I think you begin to lose the efficiencies of the MDL. And it depends on what the pieces look like. So, and MDLs have been broken up into pieces. We've had in the Vioxx litigation, you had the personal injury cases, a third-party payer economic loss litigation went to Judge Fallon in the Eastern District of Louisiana. And the securities case, I believe, went to District of New Jersey. So MDLs have been broken up. So I guess the question would be, what do you mean by pieces?
Yeah, you know, I don't like how the JPML breaks them up based on differences in the legal claims, because I think the virtue of breaking into pieces is you get some redundancy in the decisions that different judges have to make. I mean, I think that's where you gain in the accuracy, is having different people looking at the same question, and you hope that the average of, say, 10 people looking at a question is going to be closer to right than just one person looking at that question.
I don't know if that's right.
Professor Birch, I think that Mr. Seeger mentioned the concept that some counsel may be waiting for the large MDL counsel to kind of take over the cases. Do you agree with that? And if either way, please explain why, and let us know whether you think that prospect poses any problems for the idea of remanding more cases, how much of an appetite there really is there amongst a wide variety of counsel.
Sure, yeah. So, I mean, I'm going to oversimplify things here, but I think in any MDL, you see kind of three groups of lawyers. So we'll just imagine that there's three buckets. You've got the sort of repeat players that I've talked about in the past that are in a whole lot of these proceedings and that, know how the system works and, know kind of what the procedures and practices are. Then you've got the volume lawyers, for lack of a better word, the attorneys that represent a whole bunch of people, but don't necessarily work up the cases and may not be in leadership positions. And then you've got kind of the traditional trial lawyers, the lawyers that we expect would only take cases that they're actually willing to take to trial, that screen cases very heavily. So when we're talking about, would lawyers be willing to take cases up on remand? I think it depends on which lawyers we're talking about. To the extent that we care about kind of weeding out claims and we want to make sure that that cases meet kind of specific requirements that might either ultimately qualify for settlement or that might overcome, kind of causation hurdles with summary judgment, then, I think we care about the type of lawyer that those people have. And so if I'm an attorney that represents 1,000 clients in a single MDL, and I'm faced with the prospect of a remand, then there may be a whole bunch of people who find themselves without effective representation. If I'm a volume lawyer, if I'm a kind of a traditional trial lawyer, then I'm biting at the opportunity to take my case up on trial, and I'm trying to kind of get out of the MDL so that I can ultimately, advocate directly for my clients rather than having to go through the MDL procedures.
Professor Birch, I'm curious what you envision when you say you want to see more remands. Like, how many remands are we talking about? So let's take like that 3M MDL. I gather there's 300,000 cases consolidated before one judge. In your ideal world, how many of those 300,000 get remanded?
So, I don't want to put a number on it. I think it's going to depend on each case, and each case is going to be different. And there will be different benchmarks for different types of proceedings. So, I mentioned one at the very outset. I'll just give you an example using the pelvic mesh litigation. So let's say that the lead lawyers in the pelvic mesh proceeding decide that they really only want to work up the cases that have had the revision surgery, that have had the mesh actually removed, and they don't want to deal with the cases that still have mesh in place. So at that point, remand the cases that still have mesh in place, allow those attorneys to advocate for their clients. We can have other benchmarks. So at the end of common discovery, if there are case-specific motions that really depend on state substantive law, I think a lot of the MDL judges are happy enough to say, look, I'm not the foremost authority on what Georgia might say about this particular type of causation question. So let's remand it to the original district, and y'all can work up case-specific discovery if you want to. Now, the odds are those cases are likely to settle, but they may settle on more specific merits related to that case as opposed to kind of the cases as a whole. And then finally, I worry about the group at the end. And maybe it's a small percentage. I think Chris would have better figures on that than I would. But the clients that are sort of feeling forced into a global settlement or an inventory settlement, some of the plaintiffs that I've talked with as part of a procedural justice study have told me that their lawyers have told them that if they don't settle, then they're not going to get a red cent, that they're not going to continue to represent them. And so I think they really feel coerced into that kind of a settlement. Whether the remand opportunity would open things up for them or would make things more difficult for them, I think, again, goes back to what kind of lawyer they've retained.
It wouldn't surprise me that somebody, I'm sorry, Judge Grant, were you about to?
No, go ahead.
I mean, it wouldn't, on that point, it wouldn't surprise me that it would be easy to find a handful of clients that say, I'm unhappy with my lawyer or my settlement amount, or I've been told I should drop my claim. Because when you have thousands of them, it's inevitable that you're going to have folks there. And I haven't spoken to these people, but I do know that, there have been people that have been very, vocal and quoted in your book, Beth, one of which was in the Vioxx settlement. And I'm not going to get in. I mean, you mentioned her by name, and I think you talk a lot. The only thing I don't remember seeing is that she was she received the single largest award in the Vioxx settlement, and she was still unhappy. And we were talking an award that was approaching $7 million in one single settlement, and that anybody would probably. So it's easy. The question is, if you're going to be asking these questions, it's going to. And I don't mean you. I'm saying generically. if we want to study, how this is going, it's going to have to be a little deeper than just a few disgruntled lawyers or their clients. I think when we look at it, we step back and look at it in a macro sense, it has gone very well. And I also think if you're going to let perfection be the enemy of good here, we're going to destroy a system, I think, that is working very well. That doesn't mean it can't use improvements. And I'll tell you, I received a ton of criticism from the plaintiffs bar in a panel I did with you, Brian, that you talked me into and got me in trouble about frivolous claim or meritless claims. And I see myself, the clip gets played over and over amongst people who are upset with me, but I had to acknowledge as a leader in MDLs that there is some element of meritless claims. So what has happened since then, frankly, though, is that judges are aware of it, lawyers are aware of it, plaintiffs' lawyers who lead these cases don't want them either. And I think we're getting closer to dealing with that as a problem. I mean, through new mechanisms that have come out through innovation, like taking a census, improving on plaintiff fact sheets, So those are things that I would acknowledge that maybe members of the audience here would look at and say, yeah, well, how do you deal with all the meritless claims? Well, we're working on it. And first you have to acknowledge it may be an issue and then try to find some solutions to it. But that's why I like the current system. The current system allows us to do that.
Could I just jump in there?
No, go ahead.
Oh, sorry. Well, I was just going to say, on the meritless claims point, I find this a little bit frustrating. People always talk about meritless claims, but we really don't have a good definition of what meritless means. Meritless might mean that they, worked up their case, they went to summary judgment, they had summary judgment granted against them. That doesn't mean it's meritless in the Rule 11 sense. We might mean meritless in the sense that they've lost their doctor's records and that they're no longer able to provide the kind of proof that we're talking about. Or we might be meritless meaning frivolous, right, in the sort of specific sense of the word. But without a sense as to what the data says on how many claims are meritless and for what reason, I worry that we are looking, we've got this solution in search of a problem. We're doing all of these things like plaintiffs' fact sheets and census, which are driving up costs for plaintiffs. And ultimately, we don't really have a sense as to what the problem is that we're trying to combat.
I think that's a great place to start to transition to audience questions. First, I will let you all know some information you've probably been waiting for, which is the CLE password, which is LPR15. So I've got one more question for the panelists that we can use while everyone is getting geared up for your audience questions. Remember, we'll only be taking questions from Zoom. So you should use the raise hand button in the middle lower part of your screen. If you're on direct Zoom telephone, you can dial *9. Anyone who would like to ask a question will be moved to the top of my attendee list that I can see, and I'll reach out to those questions in the order that they are received. So while everyone is gearing up for their questions and raising their hands, I'll ask all three panelists for a hot take response to the question, where's the defense bar and where are defendants right now on MDLs? We've talked a lot about plaintiffs. Is there an emerging consensus or approach amongst the defense bar about how MDLs are working or not working?
Do you want me to take that one first, Judge?
Sure, go for it.
I think that well, there have been proposals made by the chamber, and I know supported by some defense firms, of rule changes that I think those folks believe would improve the MDL process. One of which, it was just recently rejected by the advisory committee to the Rules Committee, which is led by Judge Dow. One of those proposals was to allow for more interlocutory appeals. And I think the view there, and I'm going to try to do my friends some service on the defense side, and there'll probably be a few that can chime in, is that major rulings put a lot of pressure on defendants to settle, and there ought to be some mechanism for reviewing those, whether it be Galbert rulings or scientific rulings, evidentiary rulings about what could be seen at trial by a jury, and a number of things. I believe that was rejected, and rightfully so, because my view is that first of all, I think taking things up on an interlocutory appeal would cause unwarranted delay. And remember, you've got thousands of cases going to trial individually. So even if a defendant loses the first trial, they can take that case up and appeal all of those issues, the scientific rulings, all the pretrial rulings they want, while the case continues to move forward. The other thing is, I think that the panel, the advisory committee to the Rules Committee, looked at instances in which district courts were granting 1292B appeals. And I think they felt comfortable that it was being done often enough, or at least in instances where it was warranted, or they agreed with those instances where it was. And that in the instances where those appeals were granted, district court judges were not surprisingly, not being reversed. They were being actually affirmed in over 90% or something like that of the cases, which isn't a big surprise because I think generally, they are affirmed, generally. But, so I think there was no there for that particular proposal. But I mean, I'm sure you have a number of folks up from the defense bar ready to weigh in on this issue who are watching the conference. I don't know if Brian and Beth have a comment on that.
Well, Chris is certainly in contact with the defense bar more frequently than I am, and I suspect Professor Birch is as well. But what I hear when I speak to corporate general counsels is they're very unhappy with the MDL system, and they've grown more and more and more unhappy over time. I do think some of it is that they have just so much at risk by having everything in the hands of one person. If you get a bad ruling, if you get a bad judge or a bad ruling, there's not a lot you can do besides pay $10 billion. And I think that is concerning to people. And it's one of the reasons why I think we ought to consider not putting all of our eggs in one basket. If you don't like appellate review, and I think there are legitimate reasons not to like it, because every time you go up, it's going to prolong things a year or two. I think we need to find other ways to make this less of an all or nothing enterprise for both defendants and plaintiffs, for that matter. I mean, it's possible you get an outlier judge dismisses the entire MDL on summary judgment and no one gets anything. That's happened on a handful of occasions. So there's great risk to both sides to putting all our eggs in one basket, and I just don't think it's necessary.
So I don't think I have anything to add to what Chris and Brian have talked about on the defense side, but I'd love to hear from some of our participants to see if they want to chime in on any of those fronts.
Professor Birch, I'm curious, where did you come out on that proposal for more interlocutory appeals?
Well, so Professor Gluck and I have a new paper that will be coming out soon called MDL Revolution. And, I think we both recognize the need for greater appellate review, particularly on key decisions. I think that it can be effectively done through mandamus. I think we've seen a lot of that in the opiate litigation, particularly when you have kind of outsiders like the state attorney generals who are jostling for position. I worry that having kind of an additional break in terms of appellate review will slow proceedings down. That's why I tend to lean towards the remand possibility as opposed to providing greater appellate interlocutory review, even for kind of major decisions. I think that there are ways to get those reviewed now if they're real decisions of consequence.
Thanks to all three of you. It looks like we've got a question from Eric Everett. Mr. Everett, please be sure to unmute your line before you start asking your question. Mr. Everett, I think you might be muted. Let's see. Well, it seems like we're having a problem hearing Mr. Everett. Everyone, please remember you can raise your hand and ask a question of our panelists if you wish to do so. Otherwise, I will keep asking them. It's been a fascinating discussion from my perspective. What do all of you think about the prospect of MDLs becoming the new class actions of the future? Not in terms of substance, but I think the focus of a lot of litigation and discussion has been on class actions in the past. Do you think there's any prospect of MDLs overtaking class actions as one of the main vehicles that people are using and talking about?
You guys want me to try to take that? I don't know. You know, there are a number of class actions that never make their way to MDLs, obviously, because it could be that the lawyers, you know, just a particular jurisdiction makes sense. They wind up in one district and ultimately in front of a judge. Or it could just be that one group of plaintiffs' lawyers is so far out ahead of anybody else that nobody else is really jumping into the case, and it looks like it's on its way to being certified. So I don't personally see MDLs as a replacement for class actions, because I mean, even though I do know that there are still class action MDLs, I think MDLs for the future are still going to be driven by product liability claims for the most part. That's the way I see it. You know, there could be, like in Volkswagen, there were MDLs filed throughout, I'm sorry, there were class actions filed throughout the country. It was basically a consumer case, and they were sent to Judge Breyer in the Northern District of California. But I don't see that one replacing the other. I think they're very, very different. Can I make a quick point on the mandamus point that Beth made earlier, Judge? Just she brought up something very interesting. I have been seeing more over the last couple of years. A lot. I'd love to hear a defense lawyer weigh in on this. I've been seeing more mandamus petitions of district court decisions. Recently, I just saw one filed in the Third Circuit involving a venue decision in a securities class action made by a district court judge. I thought that was highly unusual for a venue issue to go up on mandamus. Third Circuit hasn't ruled on it yet. It'll be interesting to see, but it seems like, I think where Beth was going, it seems like I'm starting to see that tool used more, whereas I've been doing this now for a very long time. Mandamus was rarely used, in the past. So curious if there's been a change in thinking on that.
I just want to chime in here briefly, Judge. I know we have a few questions, so I'll be very, very quick. I'd be curious to see some data on how often these mandamus petitions are successful, because they're supposed to be extraordinary, and my sense is they're very hard to actually get granted. But I do want to agree with Chris on your question about, are class actions going to go away? I don't think they're going to go away. I think the world is going to be divided into two halves. If plaintiffs have lost a small amount of money, small stakes losses, the class action device will be used for those people. If the plaintiffs have lost a large amount of money, 25, 100 grand, we're going to see those cases going to MDLs and not to class actions.
Interesting, thank you. It looks like we've got a question from Richard A. Please make sure to unmute your line.
Yes. I heard one of the comments earlier that oftentimes the judge will say, well, I'm in Minnesota and I don't know very much about Georgia law, so I would just assume remand it to let the Georgia judges take care of it. My impression, my limited experience, is that most judges try to find a way to always apply forum law because that's what they know best, and that they kind of make up choice of law rules as they go in order to come out with that result. Is that a problem in MDL? Do MDL judges tend to apply forum law more often than they should?
So I'll just say, I haven't done any sort of formal study on what law applies in which cases. So, I can't give you any kind of qualitative numbers. But my sense is that there is a bit of a mush going on. I think that's a technical term. But you've got this, you've got a judge who is faced with cases oftentimes from 50 different states. They're trying to encourage settlement. And whether it's a formal ruling on choice of law questions or not, as soon as cases go into a settlement, then, the mush occurs. So there's much less differentiation between, Georgia law or California law or any other state's law. So, I think it happens mostly in terms of settlement, perhaps at some point in terms of, direct kind of choice of law questions. Chris, maybe you have a better sense as to that.
It was a little bit hard for me to hear the beginning of the question. And if at the end of it, I thought where the questioner was going was, are judges more comfortable applying the law of their forum? And I don't think MDLs are an exception in any respect, because the law you're going to look to is the circuit that you're in. So, and you'll apply whatever tests are there given whatever the issue is that you're looking at. So I didn't. In the settlement side, though, Beth is totally correct. You don't see the issue of different states' laws dragged into the settlement. Usually that all goes away at that point, and it's all harmonized in some kind of a compensation scheme.
Thank you. Great question and good answers. We've got our next questioner, Mr. Scott Kupke. I apologize if I've mispronounced your name. Please make sure to take yourself off mute.
Yes, can you hear me?
Yes, thank you.
Yes, this is addressed to Mr. Seeger in response to a point of Mr. Fitzpatrick. Mr. Fitzpatrick has said a few times that there's a risk to the plaintiff's bar to have a quote unquote bad judge, however you want to define that. And the question to Mr. Seeger is, why don't you have as much fear from the plaintiff's side from doing a whole bunch of work and coming up with the center of the donut on what you would consider meritorious cases in having that bad judge? Is it because that somehow the plaintiff's bar is able to steer the litigation to a favorable forum, which if you want experts to survive in the so-called, then go to the Ninth Circuit? And I'm curious. The specific question is, why, to Mr. Seeger, why aren't you fearful of the bad judge? And I appreciate your help.
Yeah, thanks for the question. So it's not that we don't, in the plaintiff's bar, have a fear. Like any attorney, we're all very competitive on both sides of the V, and the defense bar does the best they can to represent their clients, and I do the same, and so do the other plaintiffs' lawyers. So we do, we have a sense when a case is going to be MDL'd of the judges who are in play, and there may be some that have a different perception than others. But and it could just be that I turned 60, but I've just stopped sweating those issues. I ultimately, this is going to be a very unsatisfactory answer to you, but I ultimately have come to the conclusion that I don't care what a judge's ideological bent is. I've been treated fairly by judges across the spectrum. Judges are judges. I just hope they're calling the balls and strikes as the law is in front of them. Sometimes I lose, sometimes I win in that scenario. And I guess I've just been through enough of those wars to not be so hung up on that. Now that doesn't mean that I wouldn't want to be in a particular circuit on a particular issue. I'll give you an example. In the concussion litigation, one of the big issues we had was preemption. There were a couple of cases out of the Third Circuit that looked better than other circuits. I was pretty happy in the NFL concussion litigation to be in the Third Circuit. I mean, I didn't forum shop. I mean, the MDL panel sent it to a judge in the Eastern District of Pennsylvania. Just so happened that on that particular issue, I thought we would do better than the NFL would on that. And my adversary on the other side, Brad Cart, might have read that case totally differently, and if he were on here, would say something else. So, I think I'll just make this point really quickly, and I don't know if Beth and Brian have anything to add to it. Ultimately, what I value is cases that move and getting decisions. And sometimes the decisions go against us, sometimes they go for us, but keeping cases moving has a real premium, I think, for both sides.
I think it's such an interesting question, and that was a really interesting answer, Chris. I've often wondered if there is a psychological reason why an MDL judge would be more reluctant to grant summary judgment for the defendant than to deny summary judgment for the defendant. And the psychological reason is, if you grant that summary judgment, you are dismissing thousands and thousands and thousands of cases in one fell swoop. And that may be hard psychologically for a judge to do. It's maybe easier psychologically to just let the cases continue so you don't feel responsible for such a dramatic outcome. And so that's, one thing that I've kind of wondered about is maybe the plaintiff's bar isn't as afraid because there's a psychological bias against dismissing all the cases that the plaintiff's bar can benefit from, the defense bar cannot. That's total speculation and, armchair psychology here.
I'll make an observation on that in fairness. You know, I do feel like when you are handling a personal injury case, I think judges do feel somewhat the weight of that. And I don't care if it's a single incident, automobile accident, or it's a complicated case against a very sophisticated defendant like a pharmaceutical company with the best lawyers in the world. I do think there is some weight to that because something's been taken. If it's a death case or a limb or an organ. And I think I think there is an effort to really hear that case out. Having said that, I've had cases thrown out. And they've gotten to the point where they've been thrown out. And that is my point. Look, both sides, let's be fair, both sides can say, if we were sitting around having a drink, somebody on the defense side would say, love that judge, threw out this lousy case, these stinking plaintiffs lawyers sitting around go, love that judge gave me the best ruling in the world, kept all my expert testimony in, and I'm going to win this trial. I just don't think that's a fair way to evaluate the system or to make a blanket statement about judges. And I just, in the world we live in, we are kind of, I just don't like getting into the whole, I like this judge, don't like this judge, don't like who appointed that judge, don't like it. I've been treated fairly by judges all over the spectrum. And I believe I've been treated unfairly by judges all over the spectrum. So.
On that note, we'll move to Margaret A. Margaret A., please make sure you're off mute. And I'll repeat for the benefit of those of you who didn't get to write it down quickly enough the first time. The CLE password is LPR15. Margaret A., you're up.
Can you hear me?
Yes, thank you.
Great. I want to make an quick observation followed by a question directed to the two academics on the panel, although anybody can chime in as well. The observation is that Professor Birch has detailed a situation where the plaintiffs are not happy with their representation. Brian chimed in with the fact that the general counsels, as opposed to the defense bar, are not happy with the MDL situation. And so what I see is an agency problem where the clients are not happy with this monolithic situation. And my question is anybody doing a study on this? Because two economists at Emory University did predict that law would develop over time to favor the interests of the lawyers as opposed to the clients. And that's what I'm observing here. Are you aware of any economic studies being done on this problem, agency problem?
So I'll just chime in. I am not aware of economic studies that have been done on this problem. I wrote a book that Chris absolutely loves. I'm joking here, called Mass Tort Deals, Backroom Bargaining, and Multi-District Litigation. And I did look at the data that was available, but there's a very steep caveat there. And the caveat, of course, is that I can look at the procedural inputs. So I can sort of talk about lone pine orders, and I can talk about census orders, and I can talk about how that plays out. But I don't have substantive data on how people actually fare under the system. So one of the things that I'm trying to do right now is a procedural justice study where I'm actually talking to the participants, and it's focused on women's health MDLs. So things like Mirena, Yasmin Yaz, NuvaRing, the pelvic mesh litigation. And I'm trying to get a sense as to not what the substantive outcomes are, but whether people are happy with the procedures that are being used to resolve these types of cases.
For my sake, I'm not aware of any studies of the type that you described, but it makes perfect sense to say that lawyers are a special interest group like any other special interest group. They would like to engage in rent seeking if they can and create favorable opportunities to enrich themselves. So I don't think lawyers are exempt from any of that public choice analysis that we normally apply. I would just say the following, however. I understand how unsophisticated plaintiffs might be at risk of being taken advantage of rent seeking by their lawyers like that. It's hard for me to understand how general counsels of major American corporations do not have control over the defense bar. Any rent seeking the defense bar was engaged in to the detriment of their corporate clients, it just strikes me as hard to believe could take place, because these people know what they're doing in these general counsel's offices, and they can move around a lot of money to other law firms if their law firm is not behaving in the appropriate way. And so I understand the theory. I just don't see the mechanism on the defense side as plausible, but maybe my imagination is just not great enough.
Thank you, professors. With that, I think we'll go to our last question from M. Patrick. Please make sure your line is unmuted. M. Patrick, are you with us? Please make sure to unmute your line.
Yeah, I'm trying. Can you hear me? I'm talking on the phone.
Yes,
okay.
You got it.
Okay, great. I read an article shortly after Bristol-Myers Squibb was decided that predicted the result would be that you'd have more cases in MDLs because mass tort plaintiffs had to file in all 50 states, or the forum where the defendant was at home. But the prediction was this is necessarily going to lead to more MDLs, and I'm curious as to whether that's been borne out.
That's a good observation. I haven't really given it, but it would make sense, because basically what Bristol-Myers Squibb says is it's pretty much made it impossible, if not extremely difficult, to file out-of-state plaintiffs in jurisdictions like California and others. So it would make sense then that those cases would be driven into the federal system. So that would be no surprise to me. I don't know if Brian and Beth have a different view of that.
Any response from our two academics?
So I'll just say, I don't think that there has been data that I've seen that's collected specific to Bristol-Myers Squibb. The Federal Judicial Center has collected a lot of data on MDLs over time. There's a great study that was published in the Georgia Law Review by Margaret Williams, who's at the Federal Judicial Center, that looks at MDLs over the past 50 years. And you can really see kind of different fluctuations as you have an influx of, say, asbestos or pelvic mesh, and then a resolution of those cases. And so, whether there's a trend upward over time, I think we need a little bit longer to tell post Bristol-Myers.
I can only understand Bristol-Myers leading to more MDLs in one type of case, and that is cases involving small stakes class actions. Because cases that were already big stakes, these were already being filed individually, and they were already being MDL'd. The reason why Bristol-Myers could lead to more MDLs involving small stakes class actions, because you may not be able to file a nationwide class action anymore. And so you may have to file class actions around the country in various states. And if you have 50 different class actions for the same thing, now the JPML is going to create an MDL for those 50 class actions. Instead of before Bristol-Myers, you would have one nationwide class action, and you may not need any kind of MDL to adjudicate that. So that's the one instance where I could see it making some change. But I really think big stakes cases, were really not used with class actions, and were things that had to be filed individually after AmChem and were already leading to MDLs.
I thought his question was, would there be more cases? I wasn't thinking in terms of MDLs. You're right about that, Brian. But if you can't file out-of-state plaintiffs in state court where they can't be removed, there will be more cases filed into an MDL as opposed to the state court. Yeah.
Well, thank you all for those comments and your comments throughout the panel today. I really appreciate our panelists being here, and of course, everyone who joined us on the audience. Thanks for your listening and participation. Would anyone like 30 more seconds to close out?
I would just say thank you for inviting me to this. And Judge, thank you so much for organizing this and asking the questions and keeping this conversation going.
Yes, thank you to the Federalist Society, and thank you so very much, Judge Grant, for doing this.
Yeah, absolutely. I just want to echo those thanks both to the Federalist Society and to Judge Grant, and also to my co-panelists, to Chris and to Brian. It was great having this conversation with all of you.
And read Beth's book. It's great, and she names names.
I say don't read it. All right.
Well, with that, we will close a wonderful respectful debate of the sort that the Federalist Society is known for, between all these wonderful panelists who can disagree and do so in a very nice way. So a reminder that we're closing the convention for today, and please join us for the next convention event tomorrow morning at 11 a.m., which is a discussion of the law, China, and the possible new Cold War. Thanks very much, everyone. Have a great evening.